Good afternoon, everyone, and welcome to the webinar, Body-Worn Cameras and Gender-Based Violence, Practical Considerations from the Prosecution Perspective. My name is Emily Thrush, and I'm the project coordinator here at AEquitas, Prosecutors Resource on Violence Against Women, and I will be moderating today's webinar. This presentation will discuss many of the issues law enforcement, prosecutors, forensic examiners, and other allied professionals must consider when body-worn cameras are used in gender-based violence investigations. The presenter will discuss the importance of multidisciplinary collaboration at the local, state, and federal levels in order to develop effective policies that address victim safety, privacy, and autonomy. Our presenter will also discuss issues such as deactivation of the body-worn camera at appropriate points during the investigation, privacy and safety concerns, discovery, redaction, protective orders limiting dissemination, and requests under Freedom of Information or Open Records statutes. Before we begin the substantive portion, I'll provide a couple logistical notes. If you have any technical difficulties, please contact Islands directly at 1-800-799-4510, and I do recommend you dialing in on a phone because internet audio options can be sometimes unpredictable. During the presentation, we'll be asking a few follow-up questions and feedback questions, and you can use your chat option on the left-hand side of your screen to answer those questions. We will also have a few yes or no answer questions. So you'll find those lists right below the attendee list on the left-hand side of your screen. Today's webinar is hosted by AEquitas, the Prosecutors Resource on Violence Against Women, through funding from the U.S. Department of Justice Office on Violence Against Women. Our written materials, including a copy of this PowerPoint presentation and our presenter's biography, will be emailed to you after the presentation. We are also recording today's webinar for later viewing. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas' staff is comprised of former prosecutors with over 100 years of collective experience, and they conduct legal research, provide 24/7 case consultation, serve as mentors and instructors, and publish resources. Today's presenter is John Wilkinson, an attorney advisor here at AEquitas. Before John, he presents extensively on the investigation and prosecution of domestic violence, sexual assault, stalking, and human trafficking, both in the U.S. and abroad. And before AEquitas, he was the program manager for the Gun Violence Prosecution Program, Homeland Security Program, and Southwest Border Crime Program of the National District Attorneys Association. From 1998 through 2005, John served as an assistant Commonwealth attorney in Fredericksburg, Virginia, prosecuting cases involving intimate partner violence and sexual assault, including cases of campus sexual assault and domestic violence homicide. We'll send out his full biography after the webinar, and again, we will send today's PowerPoint presentation along as well. I'd now like to turn it over to John for the substantive portion of today's presentation.
Thanks, Emily. And I think that took care of it. So we're going to talk a little bit about body-worn cameras and how they may impact our violence against women crimes. We're going to focus particularly on domestic violence, but also sexual violence, stalking, but it could be any violence against women crime. So we just want to think carefully as body-worn cameras become more and more prevalent. I eventually think most every jurisdiction is going to have body-worn cameras. We have to think and anticipate how they may impact these particular crimes. These crimes are different from other crimes, and they require a different approach, different strategies, and we need to consider the impact of everything we do on the victim and be what we call victim-centered. The investigation and prosecution of these crimes have impacts on victims, and so we want to make sure that we don't do more harm than good when we're dealing with victims. Body-worn cameras can have an impact, so we need to pay attention to that and identify where we think these things might happen, where we think there might be an impact, and then try and respond in a thoughtful way. There, unfortunately, isn't a great deal of research on the impact of body-worn cameras on victims, and so what we're trying to do is figure out what are the best ways we think we can go forward until we do have more research, and so we're just going to think thoughtfully about these things as we move forward. After this presentation, we will be better able to recognize the impact of body-worn cameras on victim safety and victim privacy. So we want to think about those two things. A body-worn camera is a recording. It's a recording of the victim. It's a recording of the victim at a very particularly traumatic time in the victim's life after they've typically just been assaulted by an intimate partner, and it's going to be tough on them. So we want to think about that. Also think about the privacy of the victim and the information that the victim will routinely reveal to a police officer in the course of a typical investigation. That's all captured on a body-worn camera. So we'll be better able to recognize these impacts. We'll also be better able to identify partnerships and multidisciplinary collaborations to support and strengthen the implementation of body-worn camera policies. So we could do it just from a police department perspective, or we could do it from just a prosecution perspective, but we really need our other partners. We need advocates, we need medical, mental health. We probably want the input of defense, of the judiciary, anybody who intersects with body-worn cameras in the criminal justice system, anybody who intersects with victims. Let's get them all and get their input and figure out what's the best way to proceed. We'll also be better able to respond to defense discovery requests, public information requests, without compromising victim privacy or safety. So we'll talk a little bit about FOIA requests, requests for these information, and we'll also talk about discovery. What is going to be the best way to respond to discovery requests? We'll have to turn some of this over, or at least make it available to the defense. When we have a case that is captured on body-worn camera, how are we going to proceed in those situations to make sure that victims are safe and the information contained on that video is also safe? We'll also be better able to anticipate and overcome defense challenges to body-worn camera evidence in court. A couple things that will probably come up there, just sort of technical defenses related to malfunctioning equipment or lost recordings, but also just classic, say in a domestic violence case or a sexual violence case, information captured on a body-worn camera that the defense might use that suggests that, oh, this victim isn't behaving like a real victim in quotes. This victim is lying. This victim is doing something else. That's captured on video. So we'll have to anticipate those and figure out how we're going to handle that. So that's what we'll talk about today. So I just want to get a little bit of information from you guys. Does your jurisdiction have a written policy on the use of body-worn cameras? Please indicate to Emily whether they do, they don't, or if you're not sure. Not every jurisdiction has a written policy on the use of body-worn cameras. Some jurisdictions have no guidance for their officers, and that can be problematic. We do want to have guidance. We do want to have standards and requirements and make sure that our officers are trained on those things. So what sort of feedback did we get?
Yeah, we have, sorry about that. We have about 12 who are saying yes, they do have a policy, and we have 15 who are saying they don't have any policy. And of course, there are some who haven't been able to respond, but that's about a dozen say yes.
All right, so that's pretty good to have that many with written policies. Those that do not have written policies obviously want to consider getting together with the police department, prosecutors, advocates, medical, whoever is involved in your coordinated community response to domestic violence, sexual violence, stalking, human trafficking, and talk about can we create a policy and can it have considerations for these particular crimes, which are different and more difficult. A second question, if for those of you that did have a written policy, does your policy specifically address gender-based violence? So even those jurisdictions, and please use the feedback options to indicate to Emily whether they do, whether they don't, or if you're not sure. Most policies that are written do not have any guidance when it comes to investigating domestic violence, sexual violence, stalking, human trafficking. So they just have general guidance, but nothing specific to the crimes that we're talking about, and these crimes are different. So we do need to think about those.
So of those, about 3 say yes, 6 say no, and the responses are a little slower, but just 3 have said absolutely.
Okay, which is actually good that 3 have policies that address violence against women crimes. So that's a positive, but most would not have any particular guidance when it comes to these crimes. And so we'll talk about a few of the things that are unique to these crimes that make it important that we approach them a little differently. Not wildly differently. In good investigations, these crimes do require different types of investigations. We want to do that the same way, but we want to be cognizant that we're capturing everything on video and make considerations for some of these issues that will crop up in these particular violence against women crimes. So these crimes are a little different. They often co-occur. Domestic violence and sexual assault will overlap. Domestic violence and stalking, all three of those can overlap. We often focus when we respond to the scene of a domestic violence call on the initial reason why we were contacted, the hit, the push, the shove, whatever it might have been, and we ignore the other things that might be going on. There's often evidence of stalking. There could be witness tampering, intimidation, manipulation going on in those cases, and so we want to think about that. We also often will find that there has been sexual assault in an intimate partner relationship, so we want to think about those things too. Sometimes there could be crimes related to child pornography or other computer crimes, and sometimes organized crime, thinking here more gang crime. There could be domestic violence report, and there's gang activity related to it. So we want to think about those things. And we want to approach these crimes differently because they are different. They impact our victims differently. It's very difficult for our victims to participate in the criminal justice system response. When they reach out via 911 or some other means, they don't always anticipate how involved they may end up being in this case, and it's very difficult for them. So we want to anticipate that and make it as easy as possible for them to participate in the investigation and prosecution of these crimes. When we think about the reality of these crimes and what happens if you do any kind of work with domestic violence victims, you know that these things are very standard, very typical. They often stay with the abuser, minimize the abuse, or blame themselves for why this abuse happened. And that's often because of what the abuser is doing. The abuser is the one causing these things. They use love and guilt and shame and things like that to exercise power and control over their victims. They fail to report the abuse. Often by the time a case comes to court for the first time, we know that there have been many incidents of abuse, either emotional abuse and or physical abuse that have gone on prior to that. They fail to participate in the investigation or prosecution. They might initially be responsive at that initial call, but they slowly or sometimes quickly drop out of participation for lots of reasons. They'll request dismissal of the charges, they recant the complaint, the initial complaint, and they often testify for the abuser. So these are different from other crimes. So we don't get these sort of things in a car theft or a burglary case. These are unique to domestic violence. There are things unique to sexual violence, stalking, human trafficking, and we have to recognize that and account for it and make accommodations for that. So we'll talk about some of those things. Okay, so just to get some feedback from you all, how might the presence of video affect reporting in a gender-based violence case? And you can just chat to Emily whatever thoughts you have on that. So we're thinking about responding to the scene of, say, a domestic violence, a sexual violence, a stalking case, and we're recording. And what do you think that impact might be, if any, on a victim in that situation? And there could be a few things that affect it, but what do you think, Emily?
So there are some decreased willingness of victim to talk, or may decrease the likelihood that they would report all the information.
So that's a classic one. So is the victim, it's already a difficult situation for a victim to reach out and talk to the police regardless of being recorded or not, but now you have this added recording. So are they willing to talk to the police, or are they going to say, look, I don't want to talk to you, or are they willing to talk to the police, but they're not giving us all the details of what happened, so we're not getting the full information, the best information about everything that's going on in that case. When we respond to a domestic violence scene, it's important to find out everything that happened on that day, that incident, but we also need to get into the history of the relationship. That is important information to know so we can figure out what's going on in those cases. Was there any more?
A minimization of facts due to embarrassment, and maybe that defense attorneys will use it as evidence against victim because they would say her story changed. It could also be that statements could be admissible as excited utterances.
Okay, so several good things there. So minimization of what happened. So that's a classic that happens in domestic violence cases. Victims often minimize, not necessarily at the scene. Sometimes that happens at the scene, but we can expect that to happen after the crime occurs. Victims often change their stories. Sometimes it's sort of slight changes. Well, he didn't push me that hard. Okay. I'm going. It just went away completely. Oh, it's back. Okay, so a little technical difficulty. Sorry about that. So victims will minimize and say that things change. They'll change their story. Sometimes it's slight. They'll say, oh, I was upset that evening. He didn't push me that hard. He didn't hit me, or I started it. They'll change stories and add facts. I forgot to tell you this. And sometimes they'll recant completely. So those are things to think about. And then somebody mentioned the excited utterance hearsay exception. So that can be very helpful in introducing this into evidence. The defendant has the right to confront and cross-examine the victim. So if you have the victim present and the victim was still under the grip of the trauma of the assault when the officer interviewed them, then you have that excited utterance exception, which is important so that you can play the video and audio. Sometimes some strategies to think about are if it is hearsay and I don't have an exception, a ready exception, or I can't lay the foundation for the exception that I want to use for whatever reasons, can I play the video without the audio? The audio portion is hearsay. The video capturing things on there might be a relevant subjection. What's the point of this? It's not capturing the actual assault. It's just capturing the individuals after the assault. But maybe it would show some important information. It certainly would show the crime scene and some other things. It also may capture the defendant and things that the defendant is doing or saying. And so those would be admissible in every situation. So those are things to think about in these cases. Okay, let's move on. And then how might the presence of video affect victim privacy and safety? So again, we're thinking about these video recordings and what is that going to say about, or how is it going to impact our victim's privacy and our victim's safety? And you can private chat those responses to Emily and we can talk about that. But think about, we're recording all this and what is our response going to be and how are we going to protect victims who might be telling us things that are not only important to the case but are very private, personal details, et cetera. Did we get some responses?
Yeah, if a victim's told they're being recorded and they see the camera, they might not trust the officer. There could be potential misuse of the video by the offender when obtained through discovery. There could be retribution or even and then abuse of public record requests on posting it on YouTube or something.
Okay, so several good things there. Will the victim trust the officer if they're being recorded? What does the victim have noticed? Did the officer alert the victim that they're being recorded? Not every jurisdiction requires that, and we'll talk about some of those policy considerations. But do they trust the officer at that point? So that could be problematic for the relationship between the officer and the victim, which is an important relationship. to the video, say, in the prosecutor's office. But honestly, the defense attorney might reasonably want to say, look, I need a copy of that video because I might want an expert to look at it. I want to go over what is captured in methodical detail, which is going to take quite a bit of time, stopping and pausing, looking at the crime scene and things that are captured there. And so I don't think it's unreasonable for a defense attorney to say, I need a copy of it. So, but can we protect our victim when we turn over copies of that so defendants don't post it online or misuse it in some other way? So we'll talk a little bit about that, about protective orders for information turned over in discovery, particularly digital information, digital videos that we have to share, and how can we safely share that so that they can't claim that it was accidentally released. Also, some states have pretty permissive public records access statutes and laws, and so will individuals be making FOIA requests, Freedom of Information Act requests, and public records requests to get this information? And once they do, are they limited at all, or can they use it any way they want and post it on YouTube or some other site? We certainly wouldn't want that to happen. That could have a very negative impact on not just an individual victim, but victims in general. So we want to avoid that, and we'll talk about that. Okay. Pausing recording. Okay, so body-worn cameras in policing. Sorry, we're having a little bit of technical difficulty. Originally came about for officer safety purposes. Departments wanting to make sure officers were safe in the field and recording those sorts of things. More recently, accountability has come to the forefront with some high-profile cases, and we want accountability of officers' behavior in the field toward individuals, and also to protect officers from accusations that there was misconduct on the part of the officers. Along the way, some things that have come up, it has proved to be a valuable tool in investigations and prosecution. It can also be helpful in report writing if you can refer back to a video. It also is helpful in training and community policing, building trust amongst the community, which is a key strategy, particularly in communities where there's a gulf between the police and either the community or segments of the community. And it also it provides the officer's point of view. And it doesn't always capture everything an officer might see. It just captures straight on what the officer is viewing. So an officer might look to the side, hear something, camera doesn't capture it particularly. It's okay. It's only meant to capture what is going on straight in front of the officer. But those are some of the reasons why body-worn cameras have come into play. And, of course, none of it particularly relates to violence against women crimes. So we have to take care and think about these things as we move forward. So some of the pros related to body-worn cameras in violence against women crimes is it preserves the victim's account of what happened, and probably this account is being relayed very close in proximity to the actual event. So you're getting the victim's fresh account of the assault right at that time. It can also capture the victim's demeanor so that we see what's the emotion that is going on in there. Not every victim reacts the same way, but typically you'll see a victim who is emotional, sometimes agitated, things like that. They're typically talking to the officer, telling them what happened, and you see this emotional state. But sometimes victims have different reactions, and that'll be captured too. And that's fine. We just have to strategize about how we go forward in those cases and make sure that we have an attempt to explain victim behavior to the judge or jury that will be determining the facts and evidence. It would be tough for someone who doesn't know anything about, say, domestic violence or sexual violence to see a video of a victim with a flat affect, someone who is not emotional, not responding. They may not understand that that is a very typical response to victims who have suffered the trauma of domestic violence or sexual assault. So we just strategize about those things. The other pros is it can capture the suspect's account of what happened as well, or the suspect's spontaneous statements that they may be yelling out during the encounter. It may also capture things that the suspect is doing, trying to get at the victim, trying to make it difficult for the victim to communicate with the officers. It can capture the suspect's demeanor as well. Is he upset? Is he not upset? Are different things going on? It can also capture the crime scene so that we can see what's been going on, if things have been disturbed or broken, or if things have been cleaned up. Did the offender take time to clean up the crime scene if there were any broken items prior to the police arrival, which could demonstrate a consciousness of guilt. So we want to think about those things as well. It's very persuasive evidence for a judge or a jury when you see this account and you see the victim and you see it very close in time after the event. So that can really persuade a judge or jury in ways that by the time the victim testifies and comes to court sometime later and has been subject to the manipulation or intimidation of the offender, it's very different. So that can actually be very helpful and very persuasive. It's also helpful as a inducement for the offender to plead when that information, either from the victim, the demeanor, and from the offender are captured. It may be tougher for them to see a defense. And that initial reaction from the victim at the scene may come true, regardless of how the victim testifies at trial. So that can be helpful. It also could be potentially helpful for evidence-based prosecution if you have an unavailable victim or a recanting victim. So an unavailable victim, there will be confrontation issues, and it will have to be determined whether what is contained on the video is testimonial in nature or non-testimonial in nature. Is there information on the video that is aiding the police in meeting an ongoing emergency, or is it really just an account through a routine investigation that is being gathered for later prosecution that's being done, and so it will be testimonial. So we have to think about those issues. Is it testimonial or non-testimonial, and if it's non-testimonial, is there a hearsay exception? But a recanting victim would be present and can be confronted, so it could be useful in those situations if we're going to confront the recanting victim with the contents of the video. Those are certain things that we need to think about in these cases. So some of the downside of body-worn cameras, is it going to impact the victim's ability or willingness to talk on camera? I imagine that most victims, even when they're notified that they're being recorded, it's in that situation, whether it's right after a domestic assault or a sexual assault, it's not going to register with them particularly, and they're probably going to talk to the officer anyway. But it probably will have an impact on some victims, and that may curtail their ability to talk. So we want to think about that. Will it have an impact on a victim's willingness to report in the future? And that may depend on how this case went and how being captured on video went. And it may mean that a victim may not reach out in the future to get the help that they need. So we don't want that, and we want to think about that. Sorry, some more technical difficulties. So I'm going to move to this area. Okay. So will the victims be willing to report in the future? That remains to be seen. What about an intoxicated victim that's captured on camera? Is the defense going to use that? Are there things related to that? That's fine. We just have to strategize about how we're going to respond to that. But how will that impact a victim later? Would they call the police in the future when they need that help? We always want to have a victim-centered response. We want to consider how everything we do impacts our victims, and we don't want to lose our victims in the process of doing these difficult cases. The victim really is central to these cases, and body-worn camera video, we might think, makes them less central to the case. It's great anytime we capture evidence that takes the entire weight of the case off the victim, so it's not as stressful. We have things that we've corroborated about the victim's account so that the victim can feel like they'll be believed. But we don't want to ignore the victim either, because we've got a particularly good body-worn camera video that captures things, and now we don't need the victim as much. So just think about that. We always want to maintain that victim-centered approach and make sure that we're maintaining that even with body-worn camera. Safety issues could be impacted. Is safety information being recorded? Is there information being recorded that could put a victim at risk? Is there victim advocate interaction or conversation being recorded? That is something that I would not want to have happen ever. So make sure that if a victim and an advocate are on the scene and communicating, that the officer is not recording that. Will it have that chilling effect on future reporting if their safety is impacted? It also is going to potentially take away a victim's ability to deny to her abuser what she told the police, because it's going to be captured word for word on video. So that is a victim's own sort of safety plan. They may have their own planning to handle an abuser and reassure them that they didn't tell the police anything or that they denied anything happened. But once it's captured on video, that's that. So that may take away their ability to protect themselves. And we need to think about that and engage in safety planning to make sure that that victim is protected in other ways. And then a lot of police departments engage in the Maryland Lethality Assessment Program, or Maryland LAP program, where the officers are administering a shortened version of Dr. Jackie Campbell's danger assessment. It's about 11 questions, and it gets into the history of the case. Capturing that on video could also have safety implications for a victim, because there are often things that aren't related to the incident itself that the victim would be relaying to police. Things about the past. Was there ever forced sex? Does he own a firearm? Has he ever threatened to kill you? Do you believe he could kill you? Questions like that that don't particularly relate to this incident that could place a victim at risk. So that's another thing that I would not want to have recorded. And we should think about how we would handle those situations if an officer is administering a LAP program, and we'll talk a little bit about that. So some of the policy considerations that go along with this. When to activate a body-worn camera. So if you have no policy, then there may not be guidance. There may just be routine training guidance, but not written policy guidance. So it is important to have a written policy in these cases. It's typically addressed in policies when they exist, and usually it is during any responsive police-citizen encounter or investigation. So sometimes an officer responds to a call, and as they get out of their vehicle, they turn on their body-worn camera. Or if dispatch initiates a response, they'll turn it on then. Officers don't walk around, they don't start their shift, turn on their body-worn camera, and turn it off when they go home and capture everything. It's just in these responsive encounters. So those are typically how we're going to activate our body-worn cameras, and that wouldn't change with regard to violence against women crimes. What about notice to individuals that they are being recorded? Some departments require, or some states or jurisdictions require, no notice be given to individuals that they're being recorded. Some require that notice always be given to individuals. Make sure that you know what your state, many states are passing laws related to this, and make sure you know what your state requires in these cases. Others say that it's up to the officer when it's practical or in the officer's discretion. And others require that there be notice given any time the officer is entering or in a place where there is an expectation of privacy. So like someone's private residence, and there may be a statute that requires that you notify individuals that they're being recorded before you enter, so they can say, no, I don't want to be recorded. I don't want my home to be recorded. So those are things to think about. When to deactivate, that's a key consideration. Some would say that it should never be deactivated until the end of the investigation, until the officer is heading back to the station or whatever he's doing. Others think about at the victim's request. If a victim is going to ask that they not be recorded, what is the officer supposed to do? And this is where policy guidance can be helpful. Would an officer want to get that complaint and be willing to turn off the camera and get the victim to tell them what's going on, if that's the only way to get the victim to talk? Or do you approach it more as if the body-worn camera is like any other piece of police department issued equipment, like the officer's badge or the officer's sidearm, that they cannot remove? It might be upsetting to have a firearm, and a victim might not want to talk, particularly with someone carrying a gun, particularly if they've been abused by someone with a gun. But an officer would say, look, I can't remove that. That my department requires me to have it. And it might be the same for the video. I cannot turn it off. I have to keep it going, and hopefully the victim will talk to you. You might have to deactivate in that constitutionally protected area or where there is an expectation of privacy also. And, again, we want to follow policy. If there is no policy, make sure we know what the state laws require, because many states are starting to address this issue. So there are going to be some exceptions, those to turning it off. If you're executing a search warrant, then you probably do not have to turn it off. You might be in a constitutionally protected area, but you have this exception granting you access to it. If there's exigent circumstances, you wouldn't have to turn it off. If you have permission or consent from the individuals who have authority over the premises that you're entering, then you wouldn't have to turn it off. Now, if you get permission from one but not the other, that could be an issue, and we may have to think about whether we have to turn it off if one person who controls the premises says no, but another says yes. And there is some case law that addresses some related issues on that topic. But the final question I would ask is, does the officer have authority to be present at the location? And if he does, then you're probably okay with recording if the officer simply has presence to be there. And I think about the body-worn camera as just a more sophisticated way for an officer to record his observations. Typically, he will record what he observed in an area in a police report. Now we have a body-worn camera that's just a little more sophisticated way of doing that. So if an officer is present and could observe these things, he has authority to be present, then the body-worn camera should be fine too. You might want to deactivate in certain sensitive areas in a bathroom or a locker room. In fact, many police departments now have signs on the bathroom door, please turn off your body-worn camera before entering, because they don't want that recorded. Anytime there's victim nudity, a particular area of concern that needs to be thought about and needs to be addressed in policy is hospitals. What if you're transporting a victim to a hospital for a SANE exam and you're now maybe capturing not only protected health information of that victim, but also private information of other individuals that happen to be present at the hospital when you enter, say, in the emergency room or wherever you have to enter. And it's not always hospitals. Some SANE exams take place in different places in different areas of the country. Hospitals may not be as accessible, so some areas have clinics that provide these exams, or they happen in other places. So think about, if I have a body-worn camera going and I am taking someone to an area that might be covered by HIPAA, the Health Information Privacy and Portability Act is, I think, the official name of it. That covers the release of that information and penalizes or makes it a crime if you share information inappropriately or capture that information. So we want to think about that. Another thought about deactivating is, before a body-worn camera is deactivated, the officer should, when practicable, because I think some officers would say, look, that's just not realistic, but when practicable, announce on the video that the recording is being deactivated and why. So if an officer is going to administer a lethality assessment program, a LAP, to a victim, just say something like, the officer is now deactivating the body-worn camera to engage in safety planning or with the victim, or something like, the investigative portion of my activity is over. I'm now moving on to safety information. I'm going to deactivate the camera. If the deactivation relates to departmental policy, then that's going to be much more defensible for me in court. The defense is obviously going to raise issues related to any time a body-worn camera is deactivated, whether it's intentionally deactivated or just an equipment malfunction. So we have to be ready to address that. And one way is if it's in our policy, and explaining why it's in our policy. And that can really turn the case around on the defense. Say, oh, well, we have to turn it off at this point because we're talking about safety. These defendants are recalcitrant, and they would go after safety information. It would put a victim potentially at further risk, And so explaining that policy could be a bonus if they open the door to that challenge. But announcing why we're turning it off can be very helpful and help us defend the decision in court so that it's not a suspicious decision or that the defense will not cast suspicion on the integrity of the officer's investigation. In sexual violence cases, an initial responder may have a body-worn camera. Investigators, detectives may not, even though they may record a victim interview, say, at the station in an interview room. But the initial responder, a best practice is for that initial responder to only get a limited collection of information, just enough information to identify who the accused is, to get some basic details from the victim, transport them to health care so that they can either get a SANE exam or if the incident has occurred some time ago, that they still receive some health care response. But they don't need to get into all the details of what happened in a sexual assault. That you want an experienced, trauma-informed investigation to occur, and you want an investigator with that kind of experience who's going to engage in rapport building, who will be trauma-informed, who will listen, allow the victim to tell their account their way, who will explain why they're asking certain questions. So, can you tell me what you were wearing that night? Not because I think you invited the assault by dressing provocatively, but because I may have to collect it. So, hey, I have to ask you what you were wearing because I need to collect that in case there's evidence, DNA, or some other trace evidence on your clothing. And so explaining things. Capturing the details of the assault, including the sensory or emotional details that are very important. We'd want to do that. And having a support person present if that's appropriate and necessary. Often it's easier for a victim who's maybe developed a relationship with an advocate to have that person present. And when you're working in a coordinated community response or on a sexual assault response team where you're working regularly with advocates, you work out ahead of time what's going to happen, and hopefully the advocate understands we don't want you to interrupt. An advocate may have to interrupt if something bad is happening in the interview, or they may just simply recognize that, hey, the victim needs a break, and can we take a break? And so things like that can be very helpful. Stalking cases, again, we want to think about victim safety and privacy. The offender is going to have access to this video and may be turned over to him, and you may capture a terrified victim on there, or worse, maybe video details of the victim's residence that the stalker may not know about. Often stalking does involve dating partners, former intimate partners, and they may have that information, but not always. And so it could be an easy way for the stalker to figure out, oh, so this is the layout of the victim's home. So we just want to think carefully about some of the things that we record in those cases and what we're going to have to turn over. Also, there could be vulnerable populations that we're dealing with. This doesn't mean your policy necessarily is going to change, your body-worn camera policy is going to change, but you definitely want to make sure that officers have the appropriate training to deal with these vulnerable populations. Someone in the LGBT community may be uncomfortable talking on camera. There are ways to interview folks so that we can put them at ease and explain the process and why we're recording and things like that. Older adults and what we're going to capture there. Juveniles, can they be recorded? Does your state law allow that? So we want to look at that. Persons with disabilities, what's going to be captured there? The immigrant community may be mistrustful of law enforcement and being recorded. So we just want to strategize, train, and figure out ways to reach out to these individuals in these communities who may be reluctant to talk to law enforcement, period, regardless of the presence of a body-worn camera. But the body-worn camera's presence may add to their stress when talking to law enforcement. Are these videos being reviewed by a supervisor the way a police report is? Typically, every police report before it's submitted is reviewed by a supervisor and checked off. Is every video going to be checked? That may be impractical. There may not be the man hours or the personnel to be able to do that. But certainly, random reviews of random videos should be conducted so that there's an idea that if police misconduct is being captured on video cameras, that the police department will be looking into it. Because a lot of times people don't register complaints every time that there might be some misconduct by an officer. And if it's being captured again and again on video, you'd certainly want to know that, and random checks may be a way to capture some of those things. Obviously, if there's a complaint, you're going to pull the body-worn camera video from that incident and see what's going on. Video preservation is another issue. Some states have requirements. Their state law requires that video be evidence in a crime be retained for years. So you have to follow whatever your state's laws are, but there may need to be a legislative fix for things like body-worn camera video. It's costly to store. It takes up a lot of storage, and it's not something that once a case is over that you necessarily want to have preserved, because if it's preserved, then there's the risk that it gets released somehow. So maybe the expiration or exhaustion of the appellate process is a good time to say we no longer need to preserve this evidence. Some jurisdictions require prosecutor-ordered destruction of evidence. And so that's a fair way to say, okay, I've reviewed the case. It is okay to destroy this evidence now. Those storage issues are also going to play into this. And discovery requests are going to be unique in these cases. It's going to require additional prosecutor workload. So you might want to anticipate personnel issues in a prosecutor's office where now the police are turning over videos that you have to sit and watch carefully, and you've got to look at the entire video and identify if there's any potentially exculpatory information in there, or just turning over the video itself, is there any private information in there that you don't want turned over, personal identifying information of the victim that you don't want to turn over. So you may have to redact, and you may need special software to redact that. If you have an incident where several officers respond to the scene and they're all wearing body-worn camera video, you're going to have to look at all those videos. My former boss just recently had a case where 5 officers responded to a DV scene, and she had to go through 5 videos. She spent a weekend doing it, getting ready for turning that over in discovery. Also think about asking for protective orders when we do turn over video to defense attorney, as opposed to allowing them access to video, say in our office, where we know it's not going to be disseminated. Ask an order that further dissemination of this is prohibited, and perhaps even that the defense attorney cannot turn over the video to the defendant. He can view it at the defense attorney's office or in whatever manner they want, but he cannot turn it over to them. And prohibiting that it be disseminated any further from just the defense. So we can at least hold people accountable if for some reason that video gets released as a revenge or retribution tactic of the defendant. And the manner of delivery might be a physical disk as opposed to email or Dropbox or other file sharing services, such that there's more accountability. It doesn't mean that they won't be able to share that, but at least we'll know it's not going to be hacked potentially or distributed inadvertently because it was sent on email or something like that. Freedom of information, again, during an investigation, all the police records and the prosecution records are typically protected, and you do not have to turn them over if it will impact your investigation or your prosecution. After the investigation, you got to check your state statute. Is it considered a public record? Many states are passing laws that are determining the status of these video records. Some will say it's not a public record to protect victim safety. Others will say it is. If it is, you may have to turn it over. You may have to redact certain information to protect the victim. Some of these statutes do say if it will impact adversely a victim or a party captured on the video that you may not have to turn it over. So just look at your state statutes. We can also help you with that if you want to know what your state statute contains. And then also look at your state constitutions and state statutes related to victims' rights. Victims have the right to reasonable expectations of privacy, reasonable protection of their privacy. They have the right to be protected from the offender. So turning over some of this information could impact a victim. Maybe it's your victim's rights statute that will be the reason why you do not have to turn that over if that is the safest course. Some of the defenses are just going to be our classic DV defenses. The victim on video is not acting like a victim. The victim is captured on video lying to the police. Victim is engaged in conduct that is unlikable, whether they're intoxicated or whether they're using foul language or whether they've been caught with drugs or whether they're reacting in a negative way with the officers. So that could be a defense. Or they're engaged in some sort of criminal conduct on the video. These are classic defenses. that are potentially enhanced by the presence of the body-worn camera video. So again, it's not that we won't capture this. We do want to capture whatever happens at the scene, but we're going to strategize about how we're going to explain these things to a judge or jury, how we're going to present this evidence so that the jury or judge doesn't just say, well, I don't believe this victim because they're not acting like a victim, or I don't care about this victim because they're behaving in a way that I don't like. Other issues that are probably going to pop up are the deactivated recording. The officer deactivated for some reason or another. So that is going to cast potential suspicion on the case, and you may want to anticipate that and be ready to react to it. If the deactivation is related to departmental policy, then it is probably defensible and may be an avenue to present information about why we have these policies related to violence against women crimes, why these crimes are different. If it's equipment failure, that's going to happen. A lost recording, that could happen too. If the department maintains and tracks the incidents of equipment failure and lost recordings, that can help explain that this does happen, but it's a very, very small percentage of these cases, and it just simply happened in this case. And then if they have a response that if the equipment, once it's discovered that it failed, that you immediately notify a supervisor and you do a detailed report, things like that, that can be helped. Extra recording evidence is something to think about. Other people often are recording as well. The body-worn camera only captures what is going on right in front of the officer, not things that are happening off to the sides or behind him. And so just be aware of that. There could be other video out there. If we're creating a policy or if we're reviewing existing policies, we definitely want to collaborate with our allied professionals, our advocates, our healthcare professionals, police, prosecutors, and anyone else that you think will be helpful in crafting policy. So think about that. We also want to get input from our victims and survivors of domestic violence, sexual violence, and find out what it was like for them either to be recorded at the scene, if they were aware of that, or when that recording was played later at court or at other hearings, and what happened to that recording, or their concerns about what might happen to that recording. And we always want to have victim-centered policies in these cases. So going forward, we want to develop victim-centered policies in collaboration with our community-centered, our community partners, our allied professionals, so that we have the best policy we possibly can going forward, and hopefully we will start to gather information and evidence about how these recordings impact victims of these sensitive crimes. We want to make victim safety and privacy a priority in these crimes because it is always impacted, and it can be impacted more so with a body-worn camera recording. So how are we going to protect our victims, their safety, and their privacy? And we want to overcome defense challenges to body-worn camera evidence, how they're going to use this evidence in their case. Some resources and tools to help you. Early on, there was an acknowledgement of the International Association of Chiefs of Police, who've done a lot of thoughtful work on body-worn cameras and violence against women. They had a forum. They've released the results of that forum in a report that could be very helpful and goes through all sorts of considerations. And they also have some other resources to help you out. The Bureau of Justice Assistance has a body-worn camera toolkit. Sandy Tibbetts-Murphy with the Battered Women's Justice Project has also written on this and has considerations to think about. And Maryland Network Against Domestic Violence has guidance for the use of body-worn cameras during the administration of the LAP, the Lethality Assessment Program. So those are resources you can check out. If you have any questions or concerns or want further information or assistance on this topic, please reach out to me or anyone here at AEquitas, and we'll help you out. So thank you for listening.
Thanks, John, for your presentation, and thank you, everyone, for your patience for our technical difficulties. But just please know that AEquitas is available 24/7 for technical assistance and case consultation, concerns, questions you might have, training needs. And if any of you chatted me during the presentation and we weren't able to check in, we'll be doubling back, and please reach out to John and feel free. Like I said, we'll be sending out the PowerPoint presentation and the biography for John today. So thank you again for your participation, and we'll see you next time for one of our webinars.